Hello, my name is Michael Stokes. I'm the Head of Employment and Immigration at Harrison Clark Rickaby's, and welcome to the third and last of our series of webinars about redundancy restructuring. And today's session is about managing a complex or large-scale redundancy process. I'm going to be talking later on. My colleague Helen Cairns-Terry is presenting with me. She's going to talk about the things that you should be doing, and I'll talk about the things that might happen to you if you don't do what Helen tells you. We're just going to wait a few moments to let people join in. If they're anything like me, they'll have clicked in just at the wrong moment. They'll be rebooting, they'll be working at home. So we'll just allow a little bit of time for everyone to get properly on. It's just a background point. We're all working remotely or in little cells in the office. The signal could go down, we could lose Wi-Fi. I apologise in advance for any technical glitches that crop up. We'll try and make it up to you in another way if anything goes wrong. Helen's ready to do all my talking for me if I accidentally pull the plug out. Just before we kick off, we'll just wait for any stragglers to come on board. The previous two talks have been about spotting a redundancy situation and dealing with a relatively straightforward redundancy situation. And my experience, our experience generally, is that if an employer comes to ask for advice in that sort of situation, they've usually made their mind up and they've done quite a lot of consultation with themselves before asking for any legal advice. But usually in that situation, we can recast what they've done and help them to show their workings, because in general they'll have done something fair, they just won't have shown that they're doing something fair. The point of today's talk is really the more complex situations where it's much harder to reverse out of a difficult situation if you get yourself into it. So that's the aim of today's session, is to just alert you to the things that you need to do. Not many. It's unfamiliar to a lot of employers, but we're trying to help you see the problems coming up and try and scare you a little bit into doing what Helen tells you to do by saying the bad things that could happen if you don't do those things. So the format for this is that Helen's going to talk about the positive side of things, what you need to do when you need, for example, to start collective consultation. She'll speak for a few minutes. I'll then take over and talk about doom and gloom if things go wrong. There'll be time for questions and answers. We've already got some questions in advance. We'll deal with those. If you want to use the Q&A button to submit further questions, we'll do everything we can to answer all of the questions. If you ask an absolute corker, we'll tell you you've done that, and we may need to go offline. So prepare for that in advance. We'll try and deal with everything in one go. We'll go for about half an hour at least, and then we may go on if we've got questions sufficient to take us forward, but we'll stop in an hour at the very latest. So if I now hand over to Helen to talk about the positive side of what to do if you find yourself with a complex large-scale redundancy situation.
Thanks, Michael. So yeah, as Michael said, I'm just going to run through all the things that you need to do, run through some definitions. Unfortunately, they're quite important, so sorry to be a lawyer, but we will be running through some of those. So if I could have the next slide. So yeah, firstly, we're going to have a look at when is collective consultation required. So collective consultation is required when there's a proposal to make 20 or more redundancies in a 90-day period at an establishment. Now, quite a lot of those words have quite specific definitions to the legislation dealing with this, so I am going to run through them. So first of all, proposal. What does this actually mean? So a proposal, obviously, no final decisions have been made. As a company, you could still be considering alternatives, but there is kind of some thinking in your mind that you might have to go down the route of redundancies and potentially even collective redundancies. But it has to be more than mere contemplation of the possibilities. So you must have thought it through enough to think that there's going to be over 20 and they're going to be dismissed by reason of redundancy within that 90-day period at an establishment. So you have to have had some kind of thinking that it's going to meet all those trigger points. So this can arise quite early in the decision-making process. And obviously you don't have to know the exact number of redundancies, so you don't have to be able to say, oh, it's going to be 25 or 65. You just have to know that it's going to be over or potentially over 20 for those obligations to kick in. So basically the take-home point is that it's prudent to start consultation as early as possible. It's also worth bearing in mind that voluntary redundancies should be taken into account when determining whether the trigger has been reached. There are some slight exceptions to that, but I think in these circumstances where it's kind of probably COVID-19 related, any of those kind of voluntary schemes, if there's going to be other redundancies within that 90-day period, you need to count them for the purposes of whether you hit the 20 or more point. So what's an establishment? Again, historically, there's been a bit of confusion as to whether if you're a national company, it's, you know, everyone across the UK, are you going to make people redundant, 20 or more people, or whether it's in your local branch. And the European Court of Justice clarified that, and it is the local unit or entity to which workers are assigned to carry out their duties. So if you take any one of the large retailers that have announced redundancy plans, whether or not they have to collectively consult will depend on the number of people per store. So for example, if they had a store in Oxford where they only wanted to make 10 people redundant, the obligations wouldn't kick in. But if, say, in Manchester they had 30 people they wanted to make redundant, then obviously they would. So that's just worth bearing in mind. It's also worth bearing in mind that it's the employer that has the obligation to consult, and that sounds probably quite obvious, but sometimes it can throw spanners in the work. For example, if there's a parent company that proposes the collective redundancies in one of its subsidiaries, it's the obligation of the subsidiary employer to consult and inform, and that's even the case where the parent hasn't properly told the subsidiary about it, or they don't really know what's going on. So it's just worth bearing in mind, and obviously if you are in that situation as either the parent or the subsidiary, try and communicate well and get all the information you need just to ensure you don't fall foul of these regulations. And also group companies are deemed to be separate employers, so sometimes, especially in retail, you have two group companies that share store space, for example. If they want to make 19 people redundant each, they wouldn't have to collectively consult despite the fact that they're in the same group because they're deemed to be separate. So just little points for you to bear in mind if that is applicable to you, just so it flags up in your mind if you are considering redundancies. And it's also worth bearing in mind that dismissals to change terms of contract are deemed redundancies. And this basically goes to the definition of what redundancy is under the relevant legislation, and it's much broader than we usually think. So it's essentially any reason for a dismissal which is not related to the individual. So on current case law, that would be the kind of dismissal and re-engage, the re-engagement. It would also be situations where an employer seeks consent for a detrimental change to terms and conditions. So there was a case where a 25% cut to salary was agreed, but it was in the same time period that they were making people redundant. And they were found that the employer should have included that individual in their numbers, the terms of, and they should have consulted with him. So it's just worth bearing in mind that if you are looking at changing terms, you might need to include those people for purposes of consultation. If you use a lot of fixed term contracts, the good news is that an expiry of a fixed term contract is excluded from the definition, so you don't need to worry about if people's contracts are coming to an end during that period. You don't need to worry about them for purposes, well, you do, but not for purposes of collective redundancy. Have the next slide, please. So when do you have to collectively consult and who do you have to do it with? So obviously we talked about proposals, so it's when it's a formative stage, but you know enough that you're likely going to trigger the collective consultation process. Now, the relevant legislation states that consultation must begin in good time, and then it gives these 30 and 45-day indicators. So it's kind of saying that you should consult no later than 30 days where between 20 and 99 redundancies are proposed, or 45 days where more than 100 redundancies are proposed. And you have to do that before any of the dismissals can take place. So no dismissals can take place in that period. So think of that 30 or 45 days as the minimum. It's absolutely fine to go beyond that and take a longer time. And in fact, sometimes you might need a longer time. At the moment, given coronavirus and everything that's going on and the limitations that people are finding in terms of working remotely or not being all in one place, it might well take longer. So it's just worth kind of bearing that in mind. Those 30 and 45 days should be seen as a minimum. Yeah, a minimum. So who do you have to consult with? You have to consult with appropriate representatives, and this is going to be either trade union or elected representatives. So if as a company you have a recognised union, you've got to consult with that union. If you already have elected reps, then consult with them. If you don't have elected reps, then the affected employees will need to elect representatives for the purposes of this redundancy process. Now, in terms of kind of electing them, it has to be a fair election, as you would imagine. As an employer, it's you that needs to decide how many reps are needed, but this isn't a kind of one will do. It's okay, how many do we need to make sure that there's sufficient representation of all the interests of all the affected employees? So that does require some thought, and voting has to be in secret if possible. Obviously, at the moment, it's likely to be a remote process, so you need to think about limiting the number of people that have access to the online results, for example, or engaging a third party to have, to hold anonymous votes for you. But again, just things to think about. But it's just worth bearing in mind that consultation can't start until after you've got reps. So again, it can add time to the whole process. So build it into your timeline. There's no specific time frame, so it's not like you have to give 2 weeks for elections, but they obviously need to be fair. So that's just worth bearing in mind. And obviously it's about affected employees. So it's worth just, again, looking at the definition of what affected employees are. So obviously they're the people who are affected by the proposed dismissal, so they could be made redundant, but they're also any employees who could be affected by measures proposed to be taken in connection with the dismissals. Now, I'm sorry to bring in TUPE, but measures has been interpreted to be similar to that under the TUPE regulations. So it could be any change, big or small. So the example I always give when I'm advising on TUPE is, even if you're just changing the day that someone gets paid, you're moving it from the 26th to the 27th, that is a measure. So have a think about, after redundancies have taken place, are there going to be any changes? Are there going to be new systems of work, new working hours, variations to contracts, new reporting lines, anything like that? You just need to make sure those people are included when you're consulting. The other big point it's a small point in the process, but it's really important to get it right, is that you need to notify the Secretary of State if you are thinking about collective redundancies, and that's via a form HR1. Give it a Google, you can find it quite easily, but it's really important to do, because if you don't do this, it's a criminal offence, and the company could be faced with an unlimited fine, and also people could go to prison. So definitely one that you want to get right. Could I have the next slide, please? Thank you. So what do you have to consult people about? So the consultation process begins with the provision of information on the proposals to the elected representatives, and the things that you need to tell them about, in some ways it's quite straightforward and it's common sense, but it's the reasons for the proposed dismissals. So why are they happening? Obviously at the moment it's likely to be COVID-19 related and the impact that's had on the business, but it's important that you explain why they're happening. You need to let them know the numbers and the descriptions of the employees who you're proposing to dismiss, out of a total number of employees of any such description. So for example, you might say we're considering making 50 of our sales staff out of 150 in this office. So you're just letting people know the context of how many of a particular role you're proposing to make redundant. The proposed method of selection, again, being transparent in how you're going to assess people. The method of carrying out the dismissals, especially if you have any agreed procedures with trade unions, it's really important to make sure that you go with those because they've been agreed. And this includes things like the period over which the dismissals are to take effect. So if you are making a lot of dismissals, you might want to stagger them so you don't have 100 people leaving all in one day. You might want to stagger it over a couple of weeks, just from an administrative point of view. And you also have to include the proposed method of calculating redundancy pay, including whether there's going to be any extra or whether it's just statutory. And again, another small point that's really easy to miss but really important to put in is you have to add suitable information about the company's use of agency workers, even if that's just to say we don't use agency workers. And it's literally a sentence that just says the number of agency workers used, where they're working, and the type of work that they're carried out. Again, small but annoying if the whole process is found to be unfair because you've not done that. And then after you've given all that information, you can then consult with the representatives. And obviously that's going to be talking about are there any ways that we can avoid redundancies? Are there any ways that we can reduce the numbers of people being made redundant? Are there any ways of mitigating the consequences of dismissal? And obviously consultation is with a view to reaching an agreement. Consider and respond to any suggestions made. If you're going to reject suggestions, then make sure you're clear as to why and show that you have put thought to it. And then the classic, just make sure everything is documented. So if there is any kind of queries or disputes that come up along the line, you can say, and you can show and point to these documents to show, no, these things were discussed. So now I'm going to hand over to Michael, who's going to tell you the doom and gloom of what happens if you get it wrong.
Right, thank you very much, Helen. I'm going to mention a few ways in which the collective consultation process that Helen's just described, how that's meant to tie in with other forms of consultation, that is individual consultation with employees in that redundancy process, because it affects the timing. If you're approaching a large-scale redundancy process, it isn't the case that you have to go through the election and then go through the collective redundancy, and then you can start the collective redundancy consultation, and then you can start talking to the individual employees, and then you give notice of termination for redundancy. Some of those things are separate and independent. So the election process is first, plainly, and then you can start your collective consultation. But before you get to the end of the collective consultation process, it is perfectly all right to start talking to the employees individually, because of course, if you've watched the last webinar in this series, or if you're just used to dealing with redundancies in a general way, you know that you need to consult with the employees before you make a final decision to dismiss them. And just because in this situation that Helen's been describing, there's an obligation to consult collectively, that doesn't free the employer from a duty to consult individually as well. But you don't have to wait until the end of the collective consultation necessarily. If you're going to try to run those two processes simultaneously and overlap them, you've got to bear in mind things that can go wrong. One of the things you'll be telling your employees normally at the beginning of a consultation process is how you're going to select people for redundancy. And if you've done this before, you'll know that often the first meeting you have with an individual is after the point at which you have provisionally selected them for redundancy, because you don't tend to talk to the whole workforce individually saying you might be made redundant. You tend to talk to the people who are in real danger of being made redundant. But how can you have done that and gone through a selection process and applied selection criteria if you haven't yet consulted about the selection criteria and what they might look like? So if you started the collective consultation at exactly the same time as the individual consultation, you're already in trouble. And this goes to the first point on that slide, which is the need for genuine consultation. What is the point of collective consultation? The whole aim of it is to reach agreement. The employer and the representatives are meant to seek to reach agreement on the issues that Helen was talking about. So you mustn't go too fast, but you don't have to wait until the collective consultation is over. Another thing that's absolutely definite about the timetable is you must not give notice of termination until the collective consultation is over. So you can't run someone's redundancy notice period in parallel with the collective consultation period. That's just out. Okay, so there are some things that can't overlap. The things that can are individual and collective consultation, but be careful. Elections, I'm only going to say about that there's a whole section of the 1992 Act that gives guidance to employers about how to deal with elections. There's no one way of doing it, but if you need help, seek help from a lawyer, of course, HR advisor. There's a very good list. It's relatively easy to get right. More of a challenge at the moment because of COVID-19 and people being remote and away from the workplace. Helen mentioned consultative bodies. You don't need to have an elected representatives if you've already got them. If you've got a standing consultative body at an employer, then that can be the forum for discussion about and consultation about collective redundancies. But the thing to be careful of there is that there are some consultative bodies that are, to use a pejorative term, just talking shops. And an employer could get into trouble if they just have a group of people they tell things to and don't really have to agree anything with, and treat that body as the body they're going to consult with about collective redundancies. Same would be true of TUPE consultation. If that body hasn't got some sort of ability to make agreements, to bargain effectively, then that standing consultative body isn't going to work for this purpose, and the employer will need to arrange an election. And if that goes wrong, if you go to your friendly committee that never challenge you on anything and you never have to agree anything with them, and you purport to consult collectively with them, that's just not going to work, and there'll be challenges to that process. It goes without saying as well that predetermined outcomes are a big problem for employers. As I've said right at the beginning, as people were joining, if you're dealing with a small-scale redundancy situation, an employment lawyer, an HR advisor can often help you to present the decision that you've already made in your head after consulting with yourself about how you're going to effect redundancies. They can help you to make that more respectable and show that it's a fair decision rather than just being a fair gut reaction by an employer to a difficult situation. So we can intervene and help in that situation. But in a large-scale exercise where 20 or more people are going, it's much harder to come in halfway through and effectively dress the situation up to rescue the employer. So if you're thinking about redundancies and there are 20 or more people, the advertisement part of this is get advice sooner rather than later, because it's much harder to help you reverse out of mistakes in this collective situation. What if things go wrong? Well, can we have the next slide, please? Thank you. The remedy for employees, and it's not necessarily for the individual employee, but the remedy that's available where there's been a failure to consult collectively in line with the legislation is a protective award. And it's an application to an employment tribunal. And who makes the application depends on exactly what has gone wrong and the context. So if, for example, you're at a workplace where there's union recognition and they are the ones you should have been consulting with for all or part of your redundancy proposal, that trade union is the correct applicant, the correct claimant to the employment tribunal, and you just get the one ET1 claim form into the tribunal, which you then have to defend. But if the union succeeds with that complaint and shows that in some way you have failed as an employer to consult properly under Section 188, then the award is going to cover all of the people who are affected by the redundancies, usually the people who are being made redundant, whether or not they're union members, and that's a very expensive piece of litigation. if the failure, if there's no union recognition, so if we're dealt with the union side of things, if there is no union recognition, then various things can go wrong. You may have failed utterly to arrange any elections, so nothing has happened. And you may even have failed to to arrange elections for representatives, and then you try to talk to all the individual employees, but that's no good. That's not going to get you out of trouble if there's a duty to consult collectively. You've got to have arranged that election or given them the facilities, the opportunity to elect representatives. If you don't do that, then all of the employees affected, they can all go to the tribunal. And indeed, nowadays, and it's been the case for a good decade now, for there to be a protective award for Joe Bloggs in that situation would have to go to the tribunal themselves. There was a period, 15, 20 years ago when the law changed and an individual could make a claim that, like a union claim, could cover a wide range of employees. But nowadays, one claimant, one award to that one claimant. In an unusual situation where you've arranged elections, you've been careful and arranged elections of elected reps, and then you somehow fail to consult properly with them, that's an unusual mistake, I haven't come across it in real life, then it's the elected reps who've got the right to go to the tribunal, not the individuals and not a trade union. And those elected reps would again be, like a trade union, applying effectively on behalf of everyone that their consultation rights would cover. What's the penalty here? 90 days gross pay per affected employee, and that's a hell of a lot. If you get that wrong as an employer, that's going to cost you an arm and a leg. And the important point to bear in mind is that the way the case law is, it's not about losses caused to the employee in the same way that it might be if it was a claim, say, of discrimination or particularly unfair dismissal, where part of the compensation is to address actual loss caused by the bad behaviour of the employer. In the case of a failure to consult, it's much more of a punishment. And the way the employment tribunals look at it is that the maximum penalty for failure to consult before collective redundancies is 90 days gross pay, and the employer needs to show why that should be reduced. And that's difficult. So if you get it horribly wrong and do nothing, the tribunal is programmed now by the Court of Appeal to start at 90 days and work down, if you're lucky, if you can persuade them that there's some reason why that should happen. I think that if you get into a situation where you're worrying about whether it's 90 days or not, you're in trouble already, but there is one escape route potentially. And that is that there are special circumstances that have somehow prevented you from being able to comply with your obligation to consult. But if you're taking advice about special circumstances, again, you're down in a very deep hole and the solicitor may struggle to get you out of it. There are a number of situations that have been tried as special circumstances, including sudden insolvency, and that's been found not to be special circumstances. You've got to have a fantastic reason, some sudden and unexpected disaster must strike you for you to be able to argue that you've got special circumstances that mean that you don't have to consult for the full 30 or 45 days. Just to make a point about why 90 days, that stems from old law. Long ago, there were duties to consult for either 30, 60 or 90 days, and the penalties matched. So if you were meant to consult for 30 days, the penalty was 30 days, and 60 and 90 and so on. Nowadays, the only penalty left is 90 days, unless you can persuade the tribunal to reduce that. I think that's all I want to say about how to get things, or what happens when things go wrong. And I urge you to think hard about the 90 days protective award point, because it should encourage you to take early advice, to just get nowhere near this situation. You can, if you start too quickly, overlap the wrong things, just trap yourself in a situation from which you cannot escape, where you've exposed yourself to a claim that is going to work, and it's only a question of how much you're going to have to pay. So take care, get early advice, avoid those problems. Now, questions. I think the first one I'm going to go to is one we've had in advance, and this is going to be for Helen. There's a question about whether it's possible to withhold redundancy pay if an employee declines an alternative job offer. So Helen.
Yeah, no, so I think the important thing to first look at is whether or what a suitable alternative role is. So when you're considering whether a role is suitable or not, then you need to take into account and consider the employee's skills and experience. So do they have the right skills and experience for the new role? And are the terms of the alternative job similar in terms of status, place of work, job duties, pay, hours, responsibilities? So you're just assessing how similar it is to their old role. It's worth bearing in mind that maintaining status and pay is not necessarily sufficient to make an alternative job role suitable, because if there are clear differences, for example, if they wouldn't use the same skills or their working hours are significantly rearranged, it's unlikely to be suitable. So if an employee reasonably refuses a role because it's not suitable and they have good reason for it, then you would still need to pay them statutory redundancy. If they unreasonably refuse, then you don't have to pay them the redundancy. But it's just worth bearing in mind that if you're wrong about whether it's suitable or not, you could be facing claims for the redundancy pay, but also unfair dismissal. So it's just worth bearing that in mind when you're making the assessment, because you could get yourself into a lot more trouble and have to pay a lot more money than the statutory redundancy if you're faced with a claim.
Okay, there's a question that's come in while we've been talking, which I'll read out. There's no agreement between the company and the employees with regards to a trade union, but I'm aware that some of the employees belong to a trade union. Does this mean a union might try to involve itself? And in that situation, there are 86 employees at the site, and they're wondering, I'll say wondering, about redundancy for 36. Still not it's unannounced, it's confidential. So what involvement can the union have in that situation? I'll take this one. If there's no union recognition, then there isn't a duty on the part of the employer to consult with the trade union under section 188. But if you're going to have to arrange employee elections, I'll come back to the possibility if there's already a standing consultative body, but if you're arranging elections for representatives to consult about collective redundancies, then of course the union members may group together and campaign for a particular person to be elected. So you may end up with the union's senior person or quasi-representative on the site being elected as an elected rep for consultation purposes. You're still only dealing with them as an employee. You're not dealing with them as a trade union, though. But all it means is that you've got to be on your game and be ready to face some difficult questions, because they may be armed with a lot more backup, legal backup, than employees who aren't in a trade union. That doesn't follow automatically, but in this sort of situation, there are materials available to union members that employers may recognise, but it won't be negotiating with the trade union. It is possible for an employer in a situation where they don't mind, and there may not be many cases like this either, to actively involve a trade union where they know they've got members, even if there's no recognition. But I think most employers would just shy away from that if they got the chance. There's a question about the best selection criteria to use. This is possibly a hangover from one of the earlier webinars. I don't think there's an answer to this question. I think that it's, I suppose, the technical answer, the lawyer's answer, which is going to sound invasive, is that the employer, when they're tested on this, and that's going to be in the context of an unfair dismissal case, the assessment by the tribunal is going to be about whether the method that the employer used was fair. So was it one of the fair methods that an employer, a reasonable employer, could use? And there are loads. There is no perfect set of criteria. And the generic advice I can give is that you would want to make sure that if you've got a matrix, a set of criteria, that you try and make some of them nice and objective, that are based on records. So if you're having a skills criterion, for example, in your selection matrix, make sure you're looking in the filing cabinet to see what the qualifications are. You'd think about at least disciplinary record, attendance records, timekeeping. Try and have some objective scores. You can use service. It's a tie break. You can have it as one of a number of criteria. Don't use last in, first out. That would have been in one of the previous talks. It's just not okay anymore. It's likely to be discriminatory on grounds of sex and age. But you can use it as part of a set of criteria. You can have more subjective criteria in there as well, but you still want to make it evidence-based. So if you're going to have someone being assessed for their attitude, you need to have some comments in your selection matrix form that you can show to a tribunal one day to show why you gave them 2 rather than 5. But you can still have those subjective criteria. You should balance the two. Have a balance of objective and subjective criteria so that you look fair. But there's no one way of doing it. Another question that came in earlier on was about whether it's okay to just use an interview process. And I've come across this a lot of times, and I've got colleagues who've worked in local government, for example, where they've used competitive interviews in departmental restructuring for years, quite happily, and just assumed that that was an entirely respectable thing to do. But there's a recent case in the Employment Appeal Tribunal where being subjected to an interview process to keep your job, so just reducing the number of jobs of a certain kind, from 10 to 9, say, and make all 10 people interview for the 9 identical jobs that haven't changed, that was found to be unfair. I wouldn't necessarily say that that's going to be repeated in every case when interview processes are used, but watch out, because it's not necessarily fair. And what you're always looking for as an employer is to find something that's safe. Anyone can look on the internet, anyone can see that there's been a case saying that redundancy by interview process might be unfair, and you're going to face arguments about it if you haven't thought about it in advance. The answer to the question, can we use interviews, is yes, as long as the job roles that you're interviewing for are new. So if you're having a restructuring and the job roles in the department are changing in a big way, so that no one is being asked to go to an interview to keep their identical current job, then interview processes are fine. So they're not unlawful in any way, but watch out how you use them. I think we've reached the end of the Q&As, and I think I promised that we wouldn't keep you hanging around if we dealt with your questions. So Helen, any final comments from you?
Yeah, no, well, I guess all that's left to say is thank you so much, everyone, for joining. You will be getting an email following this, just with a quick questionnaire. I'm assured it is very quick. It's just your comments, what you liked, what you didn't like, how we can improve. So if you could just take a few minutes to do that, we'd really appreciate it. You will also be getting another email in a few days with answers to all the questions that we've run through today. and also the previous 2 webinars we've done, as well as a recording of the webinar. So if you had colleagues that couldn't come for whatever reason, then feel free to share. But that's everything. So thank you very much for joining, and I hope that you all have a good day.
Thank you.